Put yourself right in the passenger seat. You're riding shotgun with a woman named Sarah. She's driving home from work here in Canada, totally minding her own business when the absolute unthinkable happens. Red and blue lights flash in the rearview mirror. She pulls over. It's just a routine traffic stop, but within minutes, her heart is absolutely pounding. Let's dive into this explainer and see exactly what happens next. The officer walks up to the window. After a really brief exchange, he points to the passenger seat and says, "Mind if I take a quick look at your phone?" Drop yourself right into Sarah's shoes for a second here. Imagine the immense pressure of that uniform, the badge, the flashing lights bouncing off the dashboard. Every single instinct in Sarah's brain is screaming at her to just comply, to smile, to say sure, and hand the device over just to avoid making things worse. But here is the trap, and it hides behind that single word, sure. If Sarah casually hands that phone over, she steps into a massive legal nightmare. Months later, her lawyer will be fighting a brutal courtroom battle over whether her consent was truly informed and voluntary. Was it a real, known choice to refuse, or did she just cave to authority? The problem? That fight happens way after the police have already scrolled through everything. This is exactly why knowing the rule before you speak is absolutely crucial. In Canada, it's Section 8 of the Charter of Rights and Freedoms. It protects us against unreasonable search and seizure. Without a warrant or genuine informed consent, the police simply cannot search her phone. Why? Because her device holds her biographical core. We're talking finances, relationships, medical history. Section 8 exists so you don't accidentally sign away the core of your private life out of sheer nervousness on the side of the road. Under arrest, the stakes change. But what happens if this isn't just a routine stop? Say the situation escalates and the officer places Sarah under lawful arrest. She's now in handcuffs. Does this minor arrest suddenly give the state a blank check? Can they plug her phone into a computer and do a deep forensic dive into years of her private digital history? The answer is no, and that is thanks to a 2014 Supreme Court decision called R.V. Fearon. The court established 4 strict conditions. Now, don't think of these as a checklist. Think of them as strict leashes on police power. First, the arrest itself must be lawful. Second, the search has to be truly incidental to that arrest, like securing safety or preserving evidence. Third, the search must be tightly tailored. They can check recent texts or a call log, but they cannot do a forensic deep dive. And finally, officers are required to keep highly detailed notes of exactly what they looked at. But how do they actually get in? Under an arrest, police generally cannot compel Sarah to hand over her password. She can just stay silent. But what if she unlocks her phone with her face or her thumbprint? This is where it gets incredibly fascinating. The law around forcing biometric unlocks, like physically holding the phone up to Sarah's face, remains highly unsettled in Canada. Don't let anyone tell you it's a simple yes or no. So why do these leashes even exist? During that Fearon case, Justice Karakatanis delivered an incredibly powerful dissent. Read this carefully. As technology changes, our law must also evolve so that modern mobile devices do not become the telescreens of George Orwell's 1984. That is exactly what's at stake here. These rules exist to protect citizens like Sarah from permanent, unlimited state surveillance just because they made a minor mistake. The border crossing, a totally different world. Let's fast forward. Sarah's released, the dust settles, and a few weeks later, she heads to the airport for an international flight. She steps up to the customs booth. The Canada Border Services Agency, or CBSA, asks for her phone and her password. Remember that street stop? She could refuse. But here at the border, under Customs Act Section 101 and CBSA policy, she is obligated to provide that password. If she refuses, she risks having her device completely seized and detained. But hey, before you panic and cancel your travel plans, let's look at the concrete reality. 0.007%. Statistically, only about 7 in 100,000 travelers have actually had a device examined by CBSA since 2017. The odds are massively in Sarah's favor that she simply walks right through. But what if she is one of those 7? What actually protects her? Well, a massive 2024 court decision called R.V. Pike just changed the game. The court struck down limitless, random border searches of digital devices. Now, CBSA cannot just search Sarah's phone on a hunch. They need reasonable suspicion. That means they must have objective, verifiable facts pointing to a border law violation before they even start swiping through her life.
And there's a hard limit to what they can actually see. A phone is treated basically like a physical piece of luggage. CBSA officers must use airplane mode to sever the phone's connection to the internet. They can only search the files physically stored inside the suitcase of the phone itself. Your cloud storage, your live social media feeds, your remote servers, those are entirely off limits at the border.
The evidence reality check. Let's bring this all together. What happens if an officer just ignores all these rules and searches her phone illegally anyway? We need to bust the absolute biggest legal myth out there. If you watch American TV, you've definitely heard of the fruit of the poisonous tree. In the US, an illegal search usually means the evidence is automatically thrown out. But the Canadian reality is completely different. In Canada, an illegal search does not mean automatic dismissal. Instead, the evidence goes through a complex process under Section 24(2) of the Charter.
Canadian judges use something called the Grant test to weigh the situation. They have to balance how serious the police misconduct was against how deeply it impacted Sarah's privacy. And finally, they weigh society's interest in having a trial based on the actual merits of the case. This means a judge could look at an illegal search, weigh these factors, and decide that throwing the evidence out would harm the justice system more than keeping it. Yes, the evidence might still be used against Sarah, even if the police broke the rules to get it. Let's recap Sarah's journey to really lock in what we've learned today. When stopped, police need a warrant or genuine consent. When arrested, the Fearon limits act as a strict leash on what police can see. And at the border, CBSA needs reasonable suspicion backed by objective facts to search the local files on a device. And please remember, this explainer is pure civics education to help you understand how the system works. It is not legal advice. You can find our full disclaimers in the description below.
We carry our entire lives in our pockets, our finances, our fears, our locations, our loves. As the law frantically tries to keep pace with technology, the absolute most important protection you have is simply knowing your own rights. So, the next time you see those flashing lights or approach that customs booth, ask yourself, do you know who holds the key to your digital life?